I'm Dapo Akande, Professor of Public International Law at the University of Oxford and an academic affiliate at the Bonavero Institute for Human Rights.
And I'm Malcolm Wallis. I'm a judge of the Supreme Court of Appeal in South Africa, and I'm a visitor to the Bonavero Institute of Human Rights doing research here.
Malcolm, last year you were a judge in a case in South Africa where you decided that the South African government had an obligation to arrest the Sudanese president, Omar al-Bashir. Maybe you can tell us a bit about that case.
Well, he came to South Africa for an AU conference. A legal challenge was brought to say that the government was obliged to arrest him because it didn't do so. And it came to our court eventually. He by then left the country. And we held that under the statute under which South Africa acceded to the Rome Convention, the government was in fact obliged to cause him to be arrested pursuant to the ICC warrant, and that this overrode or was preferent to the statute that would ordinarily have vested him with diplomatic immunity as a visiting head of state.
And as far as I'm aware, this is the only time that a domestic court has dealt with this question. And so not only does your judgment stand in South Africa, it's as far as I know, it's still the only judgment in which this issue has been resolved. And so it's authoritative in that sense too. And in the judgment, you relied on two articles that I have written on this issue, because this is one of my areas of research. And I was and remain curious as to why you found those particular articles useful to you in your judgment.
Well, they were helpful because you had set out the structure of the ICC, how it worked with a reference from the Security Council, which this one was, one of only two, and some of the problems that arose from that reference about immunity, and the arguments in favor of immunity under Article 98. And the earlier article had been specifically about President al-Bashir and immunity. So they converged with the very problem before the court and provided a useful and very informative structure and background to the problem we were dealing with.
As a judge, you have a choice as to the materials that you refer to. Obviously, you refer to previous cases, and there are other things that you might choose to refer to. And I wonder what it is that might sort of draw your attention to a particular piece of academic writing. What are you looking for? What do you find helpful in academic writing? And what advice do you have for academics who might hope to speak beyond academia, speak to the judiciary? What are the sort of things they should be thinking about as they're doing their research and doing their writing?
Obviously, I mean, the first thing is clarity and comprehensiveness of expression. But most importantly, if you're going to want the judge, and if you're talking about the judge, you're really talking about also the profession, the practitioner. If you want them to pay attention to what you're writing, you have to write to or address the situations that they are going to encounter. We don't, by and large, have the time to be philosophers of the law. We leave that for the jurisprudence and so on. We're in the business of dealing with specific cases and specific problems.